Good morning, everybody. Happy Super Friday. Welcome to the Courtroom Files Live. Apologies for being a couple minutes late. We ran long. There we go. We ran long on the pre-show this morning. If you're not a channel member, you should become one so you too can take part in the pre-show and not have to wait for us. Let's start the day with Mindy Glazer and Miami-Dade. There we go.
Here was there's probable cause for count 1 and count 2. Reset it for the afternoon. You said NBC, right?
Yes.
Next is Harvey Kenty.
It refused.
I mean, review. Battery on corrections officer.
Right, so I guess it would potentially be,
Excuse me.
but I don't know about the prior conviction enhancements. Then we would have to determine whether or not the items would qualify as deadly.
Cause an F25 22618 for battery on a law enforcement officer. And then F25 22617. Let me review this one. What do you say? No prior conviction?
Right, so the prior conviction, I don't think there's PC on, and then we would have to determine whether or not the items qualify as deadly weapons.
Structure with a bag full of cans and a stick.
I would ask for simple battery.
CCTV. So, one battery state,
I suppose.
or it should be battery with a prior conviction.
But it doesn't really, it says that the defendant's been, let's say,
She has
arrested numerous
battery
times.
law enforcement officer.
So maybe just bad.
As for battery and resisting without, what'd you say, refusal?
Yes.
Yeah.
Otherwise,
Next case, Julie Lodana Tovar.
added to re-
Is it corrections?
Yeah, she came in on a misdemeanor. She took a plea yesterday.
Okay.
Funny.
Good morning. Ma'am, you were arrested for burglary to an occupied structure and grand theft. I will appoint the public defender's office for you.
It's unoccupied. It's a hotel utility closet.
It's burglary to structure unoccupied. Let me see.
So she was convicted of petty theft yesterday.
Ma'am, order to stay away from the Life House south of 5th at 321 Concord Avenue, Miami Beach, Florida. You're not allowed to go to that location, to that business, hotel. Stay away from it. Count 1, burglary to the unoccupied structure is $2,500. Count 2, grand theft is $2,500. Have a good day.
Judge, would you consider tap for Ms. Bolodano? This is a case from last year.
No. I got a bunch of priors, recent cases. Priors going back to the 90s. Oh, state you have an objection to that.
Yes, she just closed out a petty theft yesterday.
You got a vision judge. Go.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Per Judge Glazer's new arrangement, the audio is crappy. I really hope they get that sorted out. But let's move along. Judge Simpson just started his day a few minutes ago, so let's see what's going on there.
Sure. Or,
So-
excuse me, unmute. Hey,
Janine Kruger.
Thank you, ma'am.
Your Honor, when we set this, you may remember clients out of state, when we set this, we were hopeful there may be a resolution, but there won't be. And that we told the court we'd be requesting a continuance to the next session if that was going to be the case. And I believe that people are going to declare that they are ready to go forward.
That's correct. We've had good contact with the named victim, Margaret Anderson, who indicates that she will proceed to trial. There's been an offer to plead no contest or guilty as charged with a deferred, and I understand that's being rejected. So is charged with a deferred, and I understand that's being rejected. So we are just requesting.
Oh,
I didn't formally reject. I said, I can't do that today. I need to discuss this with
I
my client.
apologize, Your Honor. I misspoke. Just a misstatement. I apologize. So it does look like we're going to need the December dates if the court will be so kind.
okay. And, all right. Jury final settlement conference will be adjourned to December 5th, 2025, 9 a.m. Jury selection in this matter will be December 8th, 2025 at 8:30. What state is your client in?
Wisconsin?
Wisconsin?
Yes.
Jeez.
Well, they share similar colors to Maryland's team, so one of the colors.
Okay, so you're gonna get hurt. That red is not Maryland red. I just need you to know that.
All right,
All right,
I understand.
so, and we beat them anyway. So,
Maryland's good this year.
yeah, except they gotta play the whole game.
Uh,
Just, so what I will do is I will indicate this is in person. I will indicate to council, if you don't have a resolution, and regrettably, ma'am, well, it won't be regrettable. I'll need you to appear personally on that date. I'll mark it as in person. If you have a resolution, then let the court know, and I don't have a problem with Zoom. But if there's not, then,
We'll leave the offer open as well, Your Honor.
all right, very good.
And I'll be responsive to the people.
We'll do
very
it that
soon.
way. And I think she'd rather come to Michigan anyway.
Who would?
I've
Especially.
been to Wisconsin.
Thank you, Your Honor.
It's just a bunch of dairy farms. Kidding. All right, thank you, ma'am. Have a good weekend. Court does call the case. People
Thank you, Your
versus
Honor.
You're welcome. Court calls the case, People versus Gregory Sistra.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Sistrunk. Your Honor, I did a little bit more digging into Mr. Sistrunk's cases.
Go ahead.
I think I confirmed that he was transported to hospice
Okay.
by the jail. That's what the notes in our files indicate. So that's what I'm saying. I think that there was final communication that he was transported.
On a furlough to,
Right.
but so, all right, the last place this was left is that he certainly needed hospice. That was the court's understanding. The only issue was he going to a facility for hospice, or was it going to be in-home house?
That I do not know. The notes by the other attorney just indicated that he was transported to hospice.
So, all right. Regardless of that, he's not in our jail. He is someplace else, presumably under hospice care.
Right. As I mentioned, I think the other day off the record, that in the jail system, it shows him being present in the jail, but the jail says he's not physically present.
Right, and I think we determined that because it wasn't a release, it was a furlough.
Right.
So he's still a prisoner
Right.
at the jail, right, or an inmate. All right, so what would you like me to do?
We're not able to proceed, Your Honor.
So I'd ask.
After all of
I
that,
know.
like afher all of that,
It felt rude to interrupt.
that was
I
like, that
apologize.
was like an East Hope.
I apologize.
All right.
We're not able to proceed. It's a 2023 case, Your Honor, so I don't see the point.
I move for dismissal.
All right, in absentia, I will grant that. That doesn't, people being unable to proceed, this case is dismissed. Thank you.
I was talking.
No, it's okay. Good talk. Court does call the case of the People versus Safari Steel.
Ashley Phelps for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Steele. Your Honor, I do not believe Miss Steele is present. This is Miss Pate's case, but I do not believe she has an explanation for a failure to appear.
Okay, so I need to sign off on this. I don't think it's on this one. All right.
Your Honor, so my understanding is she was transferred. Let her go on accident. She did contact the clerk's office yesterday and said she was out of state.
Okay, did you hear all of that?
A little bit.
It really wasn't a whisper. I guess she was transferred to Wayne County. Wayne County on mistake let her go instead of bringing her back here. She did contact our clerk's office to indicate, so she's aware of the date, to indicate that she was out of state.
Okay. Well, I have no further information to add to that, Your Honor. But thank you for that information. Today's just an
You can
exchange.
thank Ann, I had no clue. All right, so I guess I won't issue a bench warrant because she at least contacted the court. She would have normally been in our facility. What I will do is I'll adjourn the jury final settlement conference to December 5th, 2025, 9 a.m. Jury selection, the 8th, 2025 at 8:30 in-person proceedings, and then allow you to get in contact with her and get her here. I'll need to sign off.
Yes.
I'll let you. All right,
Thank you.
thank you. Court does call the case, People versus Rodney Jones.
Good morning. Good morning, Your Honor. Edward Lucas on behalf of the defendant. I'm standing in for the attorney of record, Robert Killawell.
Your name, sir?
Oronde Jones, sorry.
Thank you. No, sir.
And Your Honor, at this time, people are unable to proceed.
I would move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Your Honor.
Thank you.
Court calls the case of the People versus Eileen Wood.
Ashley Phelps for the people.
Yeah, good morning, Tom Pietrowski on behalf of Ms. Wood, who's standing in court to my right. Good morning, sir.
Good morning. Your name?
Aileen Wood.
All right. Yes, I need you to take your hand out of your
Oh,
pocket.
sorry.
Thank you.
Your Honor, we're set this morning for final settlement conference. At this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice.
Thanks, sir.
Thank you. Court calls the case, People versus Kyle Lighton.
People.
He's still appearing on behalf of and with Kyle Lighton, who's approaching.
Good morning. Morning. Your name, sir?
Kyle Layton.
Thank you.
And Your Honor, at this time, people are unable to proceed.
Your Honor, we would move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you very much, Your Honor.
Thank you, sir.
And I'll apologize to Mr. Eastrope. His dismissal didn't take that long.
I'm gonna write it down.
It's right.
Thank you.
Court does call the case of the People versus Maya Hines.
And on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Hines.
I have two cases. Well,
1487 is not stopped. You're awesome.
deal with that case. All right. With regard to the case that's on the docket,
Sorry. With regards to that case, Your Honor, people are unable to proceed.
All right.
Move to dismiss, Your Honor.
People being unable to proceed, that case, that being 1487, that case is dismissed. That is without prejudice.
I don't think Ms. Hines stated her name. Can you state your name? Ms.
Maya
Hines?
High.
All right. I do have another case for Ms. Hines.
I don't know. You know.
In which she has a warrant. It's a case of retail fraud. You were set to appear before the magistrate, did not. A warrant was issued on that case. What I will do is this, that I'll arraign you on the warrant in the case. Ma'am, that case alleges that on or about January 7th, 2023, at the location of the Meyer store, 3825, or the other one. At the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of retail fraud in the third degree. Do you understand the nature of that charge, ma'am?
Yes.
All right, that is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that?
Yes.
All right. First question I have for you, you want to be represented by an attorney?
Yes.
This is a public defender case.
Assistant Public Defender Lauren Kearney on behalf of Ms. Hines will waive formal reading and stand mute to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to that charge. I will set a pretrial in this matter for November 5th, 2025, 9 a.m. or as your invite indicates. With reference to bond in this case, I will cancel the bench warrant in this matter. I will then set a bond in this case, amount of $5,000. Personal recognizance of other standard conditions, including no assaultive behavior or possession of any weapons. You understand that, ma'am?
Yes.
I'll also indicate you are not to possess or consume any alcohol, recreational marijuana, or any illegal drugs at this time. You understand that? I will also indicate that at this time also, you are not to enter any Meyer store in the state of Michigan. You understand that?
Yes.
All right. Thank you. See you on the 5th.
Just to give you guys an update, it's kind of a slow ramp up this morning out in the courts, so we're going to continue with Judge Simpson for a while as other places get booted up.
Public Defender Natalie Pate with and on behalf of Mr. On, who stands to my right. Please state your name for the court, sir.
Austin on.
Thank you.
Your Honor, at this time, people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you. Let's call the case People versus Jalen Robbins.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Robinson, who is approaching. Your name, sir?
Jalen Robinson. All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
My understanding is the defendant is going to be pleading guilty to the as charged to domestic violence, the 93-day offense. Upon a successful plea to that charge, at sentencing the defendant, there's an agreement that he will be sentenced under 7694A, the preferred program. That's the court's full understanding of the agreement.
Correct, Your Honor.
Correct.
Oh, very good. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth have you got. Lower your hand and state your name.
Jalen Robinson.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
All right. And understanding that, do you still wish to plead guilty?
Yes.
Yes, sir.
And to that charge, how do you plead?
Guilty. Guilty.
Thank you. Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form today, is that correct?
correct.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
Nope.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily
Yes,
of your own free will
yes,
and because you believe that you are indeed guilty of this offense?
yes,
On the date of July 11th, 2022, at the location of 4820 Washtenaw Apartment B11, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date involving a Giovanna DeMarco that makes you think that you're guilty?
just touched her when she didn't want to.
Okay. Were you guys involved in a fight of some type or an argument?
Argument,
You were involved in an
Verbal.
argument
verbal argument.
and you touched her in some fashion?
Yes, and without her consent.
Pardon?
Yes, without her consent.
Man.
Well, okie dokie, since he's gone ahead and muted, let's go down the road a bit to Lenawee County. Judge Anzalone, I believe she has people who are brought in on front of the court stuff, which basically means child support.
All right, Ms. Underwood, we are back with Mr. Pelham. So how would you like to proceed, Ms. Underwood?
Your Honor, I guess Mr. Pelham is going to take a plea today, but he does have circumstances, Your Honor, that I think that warrant the court considering letting Mr. Pelham out and giving him.
We'll talk about that after he takes the plea. So, okay. Mr. Pelham, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, I'm going to need you to speak up a little bit louder, so repeat that response.
Yes, I do.
All right, excellent. You can put your hand down. Will you state your full name for the record?
Ray Pelham III.
Right. So, Mr. Pelham, do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes.
And you understand that it's a crime to fail to appear in this court when you're ordered to do so?
Yes.
Now, you would ask for court-appointed counsel. I appointed an attorney to represent you. Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes.
Okay, you're entitled, obviously, to have a trial, and you cannot be convicted unless the evidence at your trial proves that you are guilty beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
I got to go through your advice of rights. That's why I'm going through this, Mr. Plum. You're entitled to have all the witnesses against you appear at your trial. You or your attorney would have a right to question those witnesses under oath at your trial. Do you understand that?
Yes, ma'am.
You're also entitled to have me order any witnesses you might have to appear at your trial on your behalf. Do you understand that?
Yes, ma'am.
You do not have to say anything at your trial, and if you do not testify or say anything, nothing will be held against you. And in fact, no one will even mention your silence. Do you understand that?
Yes, ma'am.
On the other hand, do you understand that you are entitled to testify at your trial if you want to testify?
Yes, ma'am.
How do you plead to the charge that you have failed to pay child support to the very best of your ability up to the amount ordered? Guilty or not guilty?
That one was guilty, right, Ms. Underwood? They're both guilty, right, Ms. Underwood?
Yeah.
Yes, guilty. Sorry.
Okay, and how do you plead to the charge that you failed to appear in this court when ordered to do so on May 12 of 2025? Guilty or not guilty?
Guilty, ma'am.
All right, so, Mr. Pelham, you are ordered to pay $251 a month in child support, is that correct?
Yes, ma'am.
All right, and would you agree that you made a payment of $800 back in February and then another payment of $200 in May of this year?
Yes, ma'am.
But you would agree that you have not paid the $251 a month as ordered to do so, other than those payments?
Yes, ma'am.
Okay, because that doesn't add up to $251 a month, right?
Yeah.
For the year, okay. And you would agree you have an arrearage as of today in the amount of $3,903.69 because you haven't been making payments?
I mean, yeah, I don't know the exact numbers. They actually told me at the jail it was like 2,900, but yeah, I'm assuming you're right.
It was 2,600 before, but since you didn't show up, more money is added up. You understand that?
Yeah, no, sure. I'm just saying, I don't know the exact number. I'm sure you're probably
So
right.
are you currently employed?
I am, ma'am.
You are not?
I am.
Well, where are you working at?
Superior Contracting.
Say it again.
Superior Contracting,
And where is that?
Pittsburgh, Michigan.
Okay, and what is your position there? What do you?
There's like
do,
3 people
labor?
there. I just build stuff. I build barns.
Okay, all right, and do you get paid by paycheck where they take taxes out?
No,
So you get a 1099 or a 1099?
I'm gonna be 100% honest. I don't know if he's gonna 1099 me or if it's just gonna be under the table. I'm not 100% certain because of the things
Give
that
you
we've
cash?
done. I don't know
Does
if
he
you
write you a
remember.
check? Does he write you a check or pay you by cash?
Usually it's either check or cash app.
Okay, all right, and how long you been working there?
I think like a year. Well, so we stopped the business for the last 5 months-ish. Because I don't know if you remember, like all the things, like we didn't get paid $178,000 for completed work last year. That's what put us in this hardship place. And then by April, like that $2,000 I gave you, that's half the money I made the first quarter. I'm not trying to not pay it.
Okay, so
And then
I
I got another
hold
job.
on, Mr. Pelham, stop talking for a minute. Hold on, because I don't really care about all that. Mr. Pelham, if you're not getting paid by your employer, you go get another job, right? Because you got babies. You got to support these. No, stop talking. So there was a period of time you weren't working for them, correct? In the last year.
Yes, I went and
Did
the
you
last
go
time we
get
had
another-
court, you told
okay.
me to get another job.
You said yes. So did you go get another job?
Yes, ma'am.
And where was that?
Fry's Painting in Hillsdale, Michigan.
Okay, and while you were working at all of these places, did you make your $251 a month payment?
Can I ask my lawyer a question? I don't understand.
Okay, so you've been working at Superior Contracting in the last 30 days.
Yes,
Did they give you money for working for them?
yes, ma'am.
Did you pay your $251 a month for September?
No, ma'am.
Did you pay it for October?
No, ma'am, not yet.
Okay, okay. Did you pay it for August?
I have not.
Did you pay it for July?
Sure did not, ma'am.
Okay, so listen, child support is pretty much like, you gotta understand, you have kids, right? You have to pay your child support. It's kind of a no fault thing. Unless you can come in and show me you're on Social Security disability or SSI. Disability is great because then they pay your kids, but, or, you know, you have a doctor's note that says you can't work, that obligation is on you. And if you get a job where you can't afford to pay your child support, then you go get a second job or a third job. I have a guy that picks up pop cans, you know what I mean, to do what you got to do. So, all right. So then you were ordered to appear back on May 12 of 25. We sent out a show cause and we mailed it to the last address we have for you, where your house number would have been 9029. Do you still live at that place?
No, ma'am, we got kicked out of that place.
When you moved, did you change your address by writing a letter to our friend of the court?
Ma'am, I didn't have an address. My whole family didn't have an address for 2.5 months.
Okay, did you provide an address where you could receive mail, like a grandparent or a cousin?
Okay, no, I didn't. And
Did you contact a friend of the court and let him know you were homeless?
No, ma'am.
Okay. All right, accept the pleas. They've been given understandably, voluntarily, accurately, and knowingly. The defendant does have full knowledge of his rights. Ms. Underwood, at this point, I will give you that opportunity to make the statement you were going to make earlier.
Your Honor, my client had to save up money to get in a place. He is in a place now. He believes there should be 1,000 being placed on his Cash App today, which he will happily pay to the front of the court. I would ask the court to release Mr. Pelham on the condition that no later than Monday, $1,000 shows up at the front of the court. And we can schedule for next Monday. And if Mr. Pelham hasn't done that, he goes to jail, Your Honor. I don't think he's going to be difficult to find because he has a family living at that apartment, which he's going to give the address to. Partner and other children. Mr. Pelham is not going to be difficult to find.
And who's going to pay that $1,000 by Monday?
Well, if he gets out, he can get on his Cash App and get it, Your Honor.
No one else can access that?
No.
My cash.
Okay. Hang on. Mr. Pelham, you can talk.
I have my Cash App card is in my evidence. I don't know if somebody can come. I don't know how that works. It's like, if they come get my card.
Can we release that?
I don't know.
You're killing me. I'm gonna call booking. Let me call booking. You're supposed to keep up on this. I know you don't work.
They got new jail commander, new
I
lieutenant.
know.
Things are totally different. I don't know anybody.
You gotta keep up on this.
Not allowed in the jail.
All right, hold on. I'm gonna find out if someone can.
Oh, good morning. Booking.
Hey, this is Judge Anselm. So I am in a hearing right now and I have a question for you. We
Yes.
used to be able to do this. I have a gentleman who's currently incarcerated. It's Mr. Pelham.
Yeah.
And he has a Cash App card in his personal effects. And I would like to release that to a family member to make his payment so he can be released.
All right, give me.
Is that something I can do?
Yeah, I believe so, but I think you have to fax us over like proof that you said that. And approved of it.
So the pre-sentence commitment could say that?
Yeah.
All right, and Mr. Pelham, who would I release that to?
I assume Haley Hamilton can come get it. I'm gonna have to make phone calls. I have no idea, man.
Okay.
Like, I'm pretty sure
All
my
right, so
mom's
as long as,
working.
hold on, Mr. Pelham. So as long as the pre-sentence commitment states that his Cash App card can be released from his personal effects to a name, then the jail would allow for that?
Yes, ma'am.
You're awesome. Thank you.
All right, thank you. Have a good day.
Bye.
Bye.
All right, Who's your other, Harry Anderson?
Haley Hamilton,
Haley, spell Haley.
Hailey,
And her last name?
Hamilton.
Just regular, like Alexander?
Yep.
Uh,
Sorry, I
Okay, all right, so, all right, is there anything else you want to say on your own behalf, sir?
Probably not, man.
Okay, are you working full-time at the construction company?
Ma'am, I work 7 days a week and have for the last 6 months. It's like it's not that I'm not trying.
Okay,
I work 7 days a week. That's all I do. It's like what?
that's great, but you know what, if you're not paying your child support, I don't care. That comes first to me. Well, I mean, if you don't care if your kids don't have things or, you know, whatever, that's fine. So it's.
Ma'am, I
sentence of-
got a question. I do have a question.
I'm done. All right, so it is the sentence of the court that you will serve 45 days in Lenawee County Jail. We are much more interested in receiving payment. So if you can pay $1,000, you can be released. I will add to the order that Haley Hamilton can receive from your personal effects at the Lenawee County Jail a cash app card. What does that card look like? Is it like red? What does it say on the front of it?
I think it's like green, like my shirt. I don't know if you call this green or yellow, but I think it has my Cash App tag on it. It's got a chip, and I think that's it. I don't really know. It's in my phone. On the back of my phone, there's a wallet case, and it's in the second slot all the way in the back.
Case of phone. Okay. Do you want your phone and contents released to her then?
Yeah, that's fine. You can give her whatever. You can give her everything, honestly. I mean, I don't know how that works.
Doug, you're not helping me out here. You're supposed to keep up on this. All right, so we will do the pre-sentence commitment that states that the phone and attached wallet case can be released, or at the very least, the Cash App card from that to Haley Hamilton, and upon payment of $1,000, the party can be released from the Lenawee County Jail. Will give you credit for 1 day served. All right. And then when you get released, you know, it's $210 a month you need to pay. Is that including money towards the arrearage, Ms. Senkowitz?
No, that's just the base amount of $210. We'll also need his address, Your Honor.
Yeah, do you have a current address?
I'm sorry, me? Yeah, 33 West Liberty, Quincy.
33 West Liberty in Quincy.
Yes, ma'am.
Okay, so you're gonna have to pay this arrearage down. So I'm gonna ask that you pay $230 a month. So I'm gonna add another 20 bucks on to pay down the arrearage. So I usually add 50, but because you're gonna pay the 1,000, I'm only gonna add 20. So $230 a month. And you gotta make that payment by the 1st of the month. All right, so you're gonna need to make your November payment by the 1st Friday of November. You got it?
Okay, so the monthly payments go the 1st Friday of the month. The month has to be paid. That month has to be paid.
Yeah.
Okay.
So you're gonna bond out, but then you need to pay $230 by the 1st Friday of each month. And I don't care if you get a check every week and you make a weekly payment. I mean, it's better than nothing. So if you pay 58 bucks a week, that will be fine too.
Ma'am, I also send my son money on Cash App sometimes. Is like that something that I should be counting towards this?
That doesn't count towards this. I mean,
Yeah, I didn't really mean for it to. I mean, I don't know.
It doesn't count towards that. Hey, if you don't pay it through us, it doesn't count. But all parents send their kids I don't know, through, I Venmo myself, but you know, all right. So, thank you, sir. Good luck.
Yep, thanks.
And that's the end of that hearing. I have such mixed feelings on this kind of stuff. See, I fully believe that you need to support your children, but the one thing that drives me nuts about the child support system is there is no accountability whatsoever for how that money that you're delivering is spent. And that is a big hole in the system that needs to be fixed, because I know firsthand that money will be wasted sometimes, and that's not right either. Let's change it up a little bit. 44th District Court, this is where Judge Meineke sits, but we're actually going to visit with the magistrate.
It's fined up to $500 and or 93 days in jail. Is that sufficient, Mr. Anga?
That's perfect, Your Honor. Thank you so much. As to that, then I would ask the court to enter a plea of not guilty as to both charges.
Okay, defendant pleads not guilty, and a not guilty plea shall enter.
Thank you.
Okay, does he live on Bobcat Trail in Indiana?
No, Judge, that's his family's residence. He actually has a residence here. I did chat that to both you and.
Oh, okay, thanks. All right, let's see that. We're on Kimes, right, Mr. Angot? Oh, yeah, okay. How long has he resided in Royal Oak?
I've been here for about 6 months, just so you know. I don't know if you can hear me or not.
I can.
Okay. I moved here 6 months ago. My girlfriend's a flight attendant for Delta, so I kind of moved to Royal Oak because of that.
Okay. You need to update your license, maybe. I don't know.
So I absolutely need to do that.
Okay, Mr. Angot, thank you for this updated information. The court appreciates that. All right. So we have the address. Is assigned counsel requested for this gentleman?
Yes, Your Honor.
Okay. Does he have an inability to afford an attorney by himself?
That is what he indicated to me, Judge. I told him that there will be a form that he'll have to fill out to
okay.
verify.
Sir, do you live with your girlfriend?
I do, yes.
Okay, do you work?
Yeah, self-employed.
What do you do?
AI solutions.
What's that?
Like voice agents for businesses that have like lousy receptionists.
Okay. And how much money do you earn approximately?
I would say like $3 to $4 grand a month.
Okay. Does that qualify him, Mr. Angot?
Judge, it's a slippery slope in the sense that while there are statutory amounts of income set that do deem somebody statutorily indigent, the MIDC does only require that the act of having to retain counsel would be a financial distress on him to a point that would require us to consider the appointment.
So defendant has to fill out the application?
Correct.
Counsel shall be assigned for this gentleman if he qualifies. Okay, Mr. Angot, what do you have to say about bond and bond conditions?
Judge, I think most important is that my client indicates to me that he has had 0 police contacts in his lifetime. Certainly, if we are to state arguendo that there's any kind of culpability to the charges today, we could, I think, point to a very bad night on his behalf, but he is presumed innocent at this point, Judge. I would ask the court to, because he does have a local address, I think that he will appear. We did speak about a personal bond. I told him I would request that because he understands being local, he will appear. He definitely intends on defending himself going forward. And Judge, I guess, you know, I want to say they're not crimes of violence. Certainly that I haven't seen a police report, so I don't know what the allegations are regarding that. But if there was anything that was directed at the police, at least that's the allegation against him. So I'd ask the court to consider a personal bond.
Okay. The court is setting a $7,000 personal bond with conditions. No money's due at this time. The conditions are as follows. Sir, you have to personally appear, whether by Zoom or in person, for any and all court events. In this case, any further exams, any and all pretrials, any further arraignments, trial and or sentencing. You shall abide by the judgment entered in this case and surrender to serve any sentence imposed. You shall not leave the state of Michigan without permission of the court. You shall not commit any crime while released. You shall not use alcohol, marijuana, or any other illegal controlled substance. You shall alcohol ETG test 3 times per month through pretrial services. You shall not enter upon the premises of O'Toole's in Royal Oak. You must contact pretrial services by 10/28/2025 by 3:00 p.m. to set up testing. You'll have paperwork in your release that will have the phone number for pretrial services. If you try to call them today, they will not know who you are because it takes 1 business day for pretrial services to get the file from the court to pretrial services. We're going to set this matter for a pretrial. That was in front of Judge K. The notice to appear will be sent to your Royal Oak address on Hawthorne. And if you qualify, you shall have assigned counsel. Is there anything further requested or required of the court on behalf of Mr. Kimes?
No, Judge, if I just may say to Mr. Keim, the pretrial services will direct you and give you all the information you need regarding what the bond conditions are going forward. Okay?
Okay, thank you.
Yes, that's it.
Okay.
Thank you.
All right. Thank you so much. That concludes the arraignment. Mr. Ant got Miss Eggleston.
All right, let's go back to Judge Simpson. He's back up and running.
You didn't have her permission to do that?
No,
Okay. And you did that intentionally?
no.
You didn't touch her intentionally.
Mhm.
He's asking if you touched her intentionally, like it wasn't an accident, like you touched her,
Like it wasn't an accident,
like you touched her,
like on purpose.
yes,
So yeah.
yes.
Okay, yes.
Okay, I'll ask the question again. Did you intentionally touch her when you said you touched her on the wrist?
Okay, yes.
You did? Okay. And that was without her consent, as we've established.
Correct.
Correct. And what is her relationship to you?
Right now, or nothing.
It's probably not good right now, but what was it at the time?
I'll say dating. Yeah.
I'll say dating.
Yeah, because we wasn't.
What was your relationship with her?
We wasn't boyfriend girlfriend, so I'll say dating. We were intimate. I don't know.
Okay, that works. All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and your time of sentencing, that the court would no longer be bound by any sentence agreement or evaluation of your case. You understand that?
Yes.
And also you would not be permitted to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right, and have the court complied with the court ruling, would it be proper to accept his defendant's plea?
Yes, Your Honor.
Yes, Judge.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond in this matter with its conditions will be Thank you, sir. You can stop by probation on your way out the hallway. They'll be on your left.
Okay.
All right, thank you. Court does call the case, people versus Samira, is it Takora?
Alexander on behalf of the people. Assistant Public Defender Natalie Pay on behalf of Ms. Takora, who I do not know or if she's present, Your Honor. I have had, oh, perfect, she's here. Let's talk on the phone. Ms. Takora, I apologize. Please state your name for the record. Samira Takora.
Thank you.
At this time, people are unable to. Motion to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, ma'am.
Thank you, Your Honor.
Court does call the case of the people versus Nicholas Stimmel.
For people.
And good morning, Your Honor, for the record.
Good morning, Your Honor. For the record, Rita Young, appearing on behalf of Mr. Nicholas Stemmel, who is present standing to my right. Sir, would you state your name for the judge?
Nicholas Stimmel.
Thank you. I thought since you hadn't been here in so long, Michelle, you just forgot where to stand.
Kinda.
It is good seeing you.
Likewise, Your Honor.
All right. I have before me a plea form that indicates that the defendant will be pleading no contest to the charge of assault and or assault and battery, the 93-day offense. On his successful plea to that's pleading as charged, there is an agreement as to sentencing that a prosecutor's deferred sentence with probation would be the sentencing case.
That is completely correct presentation of our agreement. And Your Honor, it's my understanding that if successfully complete probation, the case will be dismissed. That's right.
As part of the prosecutor's deferred. That's correct. All right. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give the truth and nothing but the truth, have you got?
Yes, I do.
Lower your hand and state your name.
Nicholas Stimmel.
Sir, it is this court's understanding that you're going to plead no contest to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Still, basis for the no contest plea.
Civil liability, possible.
All right. Still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
And well, I won't ask the last question. The court has been provided Pittsfield Township Department of Public Safety report for their case number 24-16014. Any objection to the court having reviewed that report?
None from the people. None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, after I accept your plea in between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would any sentence evaluation or recommendation to the court would no longer be bound by. You understand that?
I understand that, Your Honor.
And you also understand that you would not at that time also be allowed to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor. And it sounds like the court's not amenable to immediate sentencing.
I wasn't asked, but
Oh, okay.
by being asked, no. All right.
Yes, sir.
You just don't want to come back here, do you? You're just trying to make it like a one-stop. I couldn't do that in any event because of the nature of the charge, and it's a victim's rights case, so I'd have to have him evaluated on that. But have I complied with the court rule?
You have, Your Honor, as usual.
Yeah, right. Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation.
Thank you, Your Honor.
For a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. or
Judge.
light indicates.
I'm
That's
so-
why we don't let her come. Go ahead. What?
I'm so sorry. I have a jury trial scheduled to start in Wayne County on November 10th. And it's a CSC case, so it's going to run through the 12th, I'm sure. So I'd ask for a different sentencing date, please.
You know, I almost want to say no.
Can I zoom in for sentencing then?
No.
Okay.
No. We're going to make you come here.
Very well.
Can we? The 10th?
10th is when the jury trial starts.
Can't
Oh,
do-
December
can't-
10th, you said? Oh, that's great. Perfect.
Sure.
Yes, Your Honor. Perfect.
Sentencing will be December, actually the 12th was perfect too, but you just messed that up. December 10th, 2025, 9 a.m. or as your invite indicates, bond with its conditions will continue. Thank you, sir.
Thank you
Your
so
Honor.
very much, Your Honor. Good to see you.
Take care. Court calls the case of the people versus James Baltes.
And then on behalf of you.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Baltas. State your name for the record, sir.
James Lee Baltus.
Thank you.
At this time, you are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right, thank you, sir.
Thank you.
Court does call the case, people versus Jason Eckel.
Ready.
The people.
Good morning, Your Honor. Robert Goldman, PA 1222, appearing on behalf of alongside defendant Jason Michael Eckel, present in the courtroom this morning. Mr. Eckel, would you please state your full name for the record?
Jason Michael Eckel. All right. The plea form that the court has in front of it is that the defendant is going to plead to an added count 2 of operating while visibly impaired to second offense. The 1-year offense. Upon the successful plea of that charge, count 1 would be dismissed. Defendant is also agreeing to enter and participate in sobriety court. Is there a particular sobriety court that he's going to be entering, or?
I'm not sure that he's been screened yet, Your Honor. Counsel and I had the chance to discuss this morning, and he let me know his client's interest in sobriety court. And given some of the facts and background here, I think that's a really good option.
Got it.
So I don't know that he's been screened.
Screened as, okay, but he does agree to do that. Is that correct, counsel?
Yes, Your Honor. And he is a resident of Ypsilanti. And so
You're not, right?
I'm not, no, Your Honor.
I could tell by the way you said Ypsilanti, but go ahead.
Sorry. So we are open to a sobriety court that has room for admission. I do believe that he would qualify as a resident of Washtenaw County. And otherwise, we anticipate it to be a successful screening for admission.
Okay. And I mean, 14A has a.
I think that would be a good place to start is 14A.
Yeah.
Okay. And that's the court's full understanding of the agreement. Is that correct?
Yes, Your Honor.
Accurate, Your Honor.
All right. May I have him sworn?
Do you solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand and say your name.
Jason Eckel.
Say that again.
Jason Eckel.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired second offense. That is a misdemeanor punishable by up to 5 days to 1 year in jail, up to $1,000 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
And understanding that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty of those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
Besides my wife, no.
All right. You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
All right. On September 4th, 2024, at the location of 3900 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, remember the questions we went through?
Yes. Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What you have and how much?
Mike's Hard Lemonade, about 3/4 of a tall boy.
Okay. Were you stopped by the police or was there an accident?
Your Honor, there was a welfare check was conducted. Officers responded by way of a dispatch for welfare. Mr. Eckel came into contact with officers in the parking lot of a Lowe's retailer in light of the welfare check response.
Got it. Okay.
No accident involved, Your Honor.
Okay. And ultimately, were you arrested?
Yes.
And were you taken to the hospital for a blood draw?
It's an intoxilizer case, Your Honor.
All right. And were the results of that intoxilizer 0.09 and 0.10?
Yes.
Do you have any reason to dispute those results? Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. And had you previously been convicted of operating while intoxicated on or about December 6, 2021 in the 14A3 district court?
Yes.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation. The court would no longer be bound by that. You understand that?
Yes, Your Honor.
You also understand that you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
All right. And has the court complied with the court rule? And would it be proper to accept this defendant's plea?
The people are satisfied.
So satisfied, Your Honor.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be here on November. I'll set it for November 12th, 2025, 9 a.m. Bond will continue with its conditions. What I'm going to suggest to you, counsel, is to go down to probation at this point in time, indicate his interest in sobriety court, and see there are 2 probation officers working down there at this point, my probation, as well as the sobriety court probation person. So let them know that and let them direct you as to how he should proceed.
Will do, Your Honor. Thank you.
Thank you.
All right, let's switch things up a little bit. We'll go down to Texas in our never-ending efforts to give you 9 to 11% more Judge Boyd. Let's go there.
State versus Marlon Daniels. Can I have parties announced for the record?
Megan Galloway for the state.
And for the defense?
George Sharman on behalf of the defendant in these cases.
All right, and you're Mr. Daniels?
Yes, ma'am.
All right. Mr. Daniels, the court, at the request of your attorney, had a PSI ordered. And Mr. Daniels, we're going to proceed with sentencing. And each of the cause numbers, you entered a plea of guilty, and the punishment is to be assessed at 18 years in the prison. Mr. Daniels, I've had a chance to learn more about your background from your attorney, your military service. And I will tell you, I know that no one, at least I have yet to have someone come before me and say, my intention was to get drunk and go out and hit somebody, or get drunk and drive drunk. Nobody ever intends to drive intoxicated or get to that point, but it happens. And that's why I always try to stress to everybody, please, please, if you're going to be drinking at all, even if you think it's just going to be one drink, it's better just to have a designated driver, right? And I do appreciate the fact that you entered a plea, that you accepted responsibility by pleading guilty, and that you have not wavered and try to blame something else for this. I do note that you said that you couldn't remember, but you know it's true, and I appreciate that. Sometimes people will say, well, I don't remember what happened, so I'm really not responsible. But you didn't do that. And the fact that you entered a plea, and in each of these cause numbers, you were looking at 20 years. And I always tell people, when people go to jury trial, even when I was a defense attorney or as a prosecutor, I sometimes would have to explain to families, you don't know what 12 people are going to do, right? When you go to jury trial, you don't know. 12 people could say, you know what? This person before me is a military veteran. This person before me hasn't been in trouble. Yes, they did this, but we're not going to give them 18 years. Who knows? A jury may decide to have given you 2 years or 3 or 4 or whatever. You just never know. So for you to accept responsibility, for you to take the 18 years, knowing that by taking these 18 years, there is no appeal because you waive your right to appeal. I think that says a lot, even though I know that the family is in a lot of pain, because when you lose someone and you lose someone this way, it's not expected. So the court is recognizing that you entered pleas of guilty to each cause number, that you accepted responsibility, and you took close to the maximum sentence in each of the cause numbers. With that being said, and cause number 2024 CR 009218, the court will follow your plea bargain agreement as previously stated. When you entered your plea, the court is finding you guilty. The court will sentence you to 18 years in the prison. There's a $2,000 fine. The court will give you credit for any time served, and legally, you're entitled to any time that you have served on this case. This will run concurrent with 2024 CR 009219. I'll request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. It's merely designed to help you maintain your sobriety, address any type of mental health or substance abuse issues you may have, so that ultimately when you're released from prison, you will maintain your sobriety. And there's an affirmative finding of a deadly weapon.
May I address the court on the matter?
Just one moment.
Yes.
And cause number 2024 CR 009219. The court is finding you guilty. The court will sentence you to 18 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. This will run concurrent with 2024 CR 009218. There is to be restitution of $60 to DPS for testing. And the court will recommend the therapeutic community. There's something you wish to say, counsel?
Yes, on the PSI, it said that he had the combat risen. He did not have combat ribbon. So that was erroneous.
Okay.
Step number 2, it shows there were 2 priors. Misdemeanors, there was only 1. And if you look at it, it's the same date on each.
Okay. All right, is there anything else?
That's all we have.
All right, Mr. Daniels. Deputy Lauren, if you're giving us trial court certification.
Correct.
All right. Counsel? Counsel.
Yes.
All right, your your client has been removed from the courtroom. Did you review the trial court certification of defendant's rights to appeal with him?
I did.
All right. On the record, the court informed the defendant that by entering the plea, he had waived his right to appeal, so he acknowledged that. I followed the plea bargain agreement. So because I followed his plea bargain agreement and because he's waived his right to appeal, he do not have the court's permission to appeal.
I went over that with him, Judge, so he understands.
All right, thank you. Is there anything else from either side?
Well, Judge, I don't know if Mr. Sherman wanted to bring this to your attention, but because the defendant is going to be in custody, I did see that he filed motions to remove the ignition and the lock. Your motions to.
Yes, she's already signed.
Okay,
Yes, I signed those,
we have no
yes.
objection to that.
All right, thank you.
And then we do have victim impact, but
All right, so who are the people here for victim impact?
there's the father.
Okay.
Well, the father and husband of the victims, and then the daughter and sister.
Okay. All right, so everyone, just give us a moment. We're gonna have medical check him out to see what's going on. And then if you will be patient, we'll have him brought back out if they say that he can be brought back out. And then you can give your victim impact. So what's going on? Okay. Okay. So Mr. Sherman? Hi, are you gonna, you'll need to remain? All right, thank you. Are you already on?
Well, we'll get back to her in a minute, but, I was going to do an Aura ad read, but now it makes total sense to do that. So let's talk about today's sponsor, Aura. And I bring this up because of what's going on in the chat right now. Barbara is actually telling a story about how a family member of hers, her social security number was stolen, and now there's like this identity theft situation going on. And this is a problem. And right there in real time, we're seeing it where your personal information gets out there online, somebody grabs it, you have problems, and then you're forced to deal with it. And this is where Aura can come in handy for sure. Basically, it's a one-stop shop for trying to secure yourself online. Nobody's going to be able to do it 100%, but you have to at least give it a try. And Aura, in my opinion, is one of the best at it, because I not only have them as a sponsor, I'm also a customer of theirs now. Transaction monitoring, identity protection, spam and junk email removal, a VPN and antivirus. They're monitoring your credit. They've got parental controls, basically everything that you have to protect yourself. And one of the biggest things that they do is they're constantly monitoring the data brokers online. My Aura dashboard shows over 50 data brokers now that they're actively monitoring and continually removing my information from when it shows up there. Because what happens is your information gets to these data brokers, gets to these places online, bad actors get a hold of it, and then we see stuff like Barbara's communicating in the chat right now. So, like it or not, this is something that we all have to deal with, and you can't deal with it alone, unfortunately. You have to have help. But that's where Aura comes in. If you go to aura.com/TCF, because you're a viewer of this channel, you get a 14-day free trial. You'll find out within 24 hours where all of your information is, and Aura will show you what they're doing about it to get it removed from those places. And generally, it's very quick. You'll find out in those 2 weeks just what they can do for you, and then at that point you can make a very informed choice as to whether or not you want to continue with them. I'm betting that you will. I have. Like I said, I'm a customer of theirs now. So again, aura.com/TCF, scan the QR code on the screen, type it into your address bar on your browser, use the link in the description, whatever you got to do, but get there. You have absolutely nothing to lose. Protect yourself online. As Barbara is pointing out in the chat right now, it's something you kind of got to do. Again, aura.com/TCF. Let's go back to Judge Simpson, and then we'll get back to Judge Boyd later once they get sorted out whatever's going on there.
Sir, it is this court's understanding. Excuse me one moment. This is court's understanding that you're going to plead guilty to the charge of domestic violence second offense. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
And understanding that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. It's on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yeah. Yes, sir.
On the date of May 2nd, 2025, at the location of 3000 Carpenter Road, in Pittsfield Township, Washtenaw County, State of Michigan, what did you do to Tamika King that makes you think that you're guilty?
We ended up getting into a physical altercation.
So, okay, so you were in an argument,
Yeah.
and what did you do with reference to that physical altercation?
It got physical.
Pardon?
Me and her, it got physical.
Okay. What did you do?
Oh, I put my hands on her. That's basically what you're saying, sir.
Okay. And you didn't have her permission to do that?
No, sir.
All right. And you weren't acting in self-defense at the time?
No.
All right. And you did that intentionally, is that correct?
Yes.
All right. And who is she to you?
My ex is my ex-wife.
At the time, was it your ex-wife?
No.
Okay, at the time it was your spouse.
Yes.
All right. Had you previously been convicted of the same type of an offense on or about, I don't have it here.
Your Honor, I have the date on the offense numbers of 6/18/2013. The previous.
6/18/2013. All right. Had you previously been convicted of domestic violence on that date?
Yes.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence recommendation or evaluation. The court would not be bound by that. You understand that?
Yes, Your Honor.
And you understand that you could not withdraw your plea?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
November 10th. Oh, no, November 17th, sorry.
November 17th, 2025, 1 p.m. What I was going to indicate, I don't know if on that other DV case, I think we got the wrong date.
We corrected it.
You corrected it.
Yes.
Okay, very good. All right. Bond will continue with its conditions. Thank you, sir.
Thank you, Your Honor.
Court calls the case, People versus Christopher Banks.
As Peltis with people.
Public Defender Natalie Pate with and on behalf of Mr. Banks, who stands to my right. Please state your name for the record, sir.
Christopher Banks.
Thank you.
There we are 6 mornings for final settlement. This time people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you, sir.
Thank you, Your Honor.
The peer.
They,
Okay.
both are.
Court does call the case of the people versus Uris Hernandez. We have an interpreter. May I have the interpreter sworn?
Raise your hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using the best skill and judgment to translate from English into Spanish and from Spanish into English in the matter now before the court, so help you God?
I do. All right. Thank you, sir. Good morning. Go ahead, Counsel.
Nash Feltus for the people.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Hernandez, who stands to my right. Please state your name for the record, Mr. Hernandez.
What is Hernandez?
At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Thank you. Thank you, Mr. Interpreter. Court does call the case, people versus David Wagner.
Nash Feltus for the people.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Wagner, who is approaching. Please state your name for the record, sir.
David Charles Wagner, Jr. Thank you.
Some people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. You have a good day. You do the same, sir. Court calls the case of the people versus the Darians. Is it Stephanie Town
Nash Feltus for the people.
or Stephanie Town?
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Staffney Towns. State your name for the record.
Adarian Townsville. I really don't go by Staffney. Just I got two last names, but I really only go by Townsville.
But you got two names.
I know. I don't know why my mom did that.
You don't know what?
Why my mom did that.
But you don't like it, so you just keep one?
Yeah. I'm sorry. I just keep one. Yeah.
Is it the first one or the last one?
The last one, Townsville. Adarian Townsville is what I go by. With Staffney Townsville.
What's your mom say about that?
Like my mom's last name is Townsville. My dad's last name is Staffney. So she just gave me both.
Oh, what's your dad say? But you don't want to carry his name?
No.
Oh, well, never mind. My bad for asking. All right. Okay. I get it. All right. What are we doing on his case?
Unable to proceed, Your Honor.
All right.
Move to dismiss.
People being unable to proceed, this case is dismissed.
All right, thank you.
That's without prejudice. You take care of whatever your name is. All right. Court calls the case, people versus Giselle Safer.
Nash Feltus for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Seyfried. State your name.
Giselle Seifert.
We're here today for a final settlement. This time people are unable to proceed.
Move to dismiss.
I've never said your last name.
Sorry.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the people versus Lucille Slater.
Nash Feltus for the people.
Apologize about that, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Ms. Slater. Please state your name for the court, ma'am.
Lucille Slater.
All right, I have before me a plea form indicates that the defendant will be pleading no contest to the charge of disorderly person jostling, the 90-day offense. Upon their successful plea to that charge, count one would be dismissed. There is a sentence agreement between the parties of a prosecutor's deferred sentence. That's the court's full understanding.
That is correct, Your Honor.
And that is our full understanding of the agreement as well, Your Honor.
May I have her sworn?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead and state your name again.
Lucille Slater.
All right, ma'am, it's this court's understanding that you're going to plead no contest to the charge of disorderly person jostling. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes.
You understand what a no contest plea is?
Yes.
All right. Two things about a no contest plea I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand
Yes.
that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. And ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're waiving or giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And doing it of your own free will?
Yes.
All right. Court has been provided and has reviewed Saline Police Department report for their case number 25-1760. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Ma'am, based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, if I accept your plea, I do have to advise you that if you commit misconduct between the time that I accept your plea and the time of sentencing in this matter, that you would then not be entitled to any sentence evaluation or recommendation. The court would not be bound by that. You understand that?
Yes.
And you would not be permitted to withdraw your plea. You understand that?
Yes.
All right. Are the people, is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court ruling? Would it be accepted?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. or as your invite indicates. Bond with its conditions will continue.
Thank you, Your Honor.
Court does call the case People versus Anthony Williams.
And is that on behalf of the people?
And Assistant Public Defender Natalie Pickwick, and on behalf of Mr. Williams, who stands to my right, please state your name for the record, sir.
Anthony Williams.
Your Honor, I believe we're going to be looking for an adjournment to December. We're working on a resolution, but through my own fault, I need to run some things by my supervisor before offering a potential resolution. So I'd be asking for an adjournment out to that date.
The objection to that?
No, Your Honor, and I have discussed that and the reasons for that with Mr. Williams, and we are in agreement of the adjournment to the December date.
I will adjourn jury final settlement conference to December 5th, 2025 at 9 a.m. Jury selection, if necessary, will be December 8th, 2025 at 8:30. Both of those proceedings are in person. All right. Thank you, sir. Bond continues. Court calls case People versus Shanice Greer.
That's the bills for the people.
Morning, Your Honor. Edward Bruce on behalf of Shanice Greer. I'm standing in for the attorney of record, Robert Kilwell.
All right. Good morning. Your name?
Denise Greer.
All right.
Your Honor, we are unable to proceed.
I would move to dismiss.
All right. And ma'am, you have no objection to Mr. Durkin stepping in for your.
Oh, no, no objection at all.
All right.
That's very kind and considerate of you, Your Honor. Kilwell did say that you're very kind and considerate.
Is that what? I've got a whole week without hearing that. People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, ma'am.
Thank you.
Thank you.
Let's call the case People versus Issa Awad.
Ash Feltus with people.
Good morning, Your Honor. Let's support on behalf of Issa Awad. Oh, sorry.
All right. Okay, and your name, sir?
Issa Awad.
Thank you.
Your Honor, this time people are unable to proceed.
Thank you. We ask that the matter be dismissed.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you.
Thank you.
He wants me to ask you
It's-
about getting the dog back.
It's my
About
dog.
what?
Is he free to sue getting the dog back?
It's my daughter's birthday this month. She's been asking about it like, ever since that happened.
I think the dog is in the custody of the Humane Society, so he's gonna have to sort
But I
that.
think what I'm asking for is that there will be no order preventing him from getting the dog back since the case.
I'm not gonna order that. The case has been dismissed. But you're gonna likely have to deal with the Humane Society regarding that.
Can I ask what's in the bond conditions?
What was in his bond conditions? Are you saying regarding animals or just?
Contact with the dog or ability to regain custody.
His only bond condition that looks like it deals with animals, that he couldn't go to the area of the Blue Pearl and that he was not allowed to possess any animals, but
Right.
those would disappear because
All right, and how do we get a copy of the dismissal?
they can get that up front. Yeah.
Okay, thank you.
Thank you so much, Your Honor.
Thank you, sir. Court does call the case People versus Alexis Brown.
Ash Feltus with people.
Miss Lonnie said that this time.
Do you remember her?
I see. But you didn't indicate the phone.
Assistant Public Defender Lauren Perny on behalf of Ms. Brown. I think what the court is discussing is Ms. Brown at her last hearing said she did not want the public defender's assistance. However, since then she has changed her mind. So
And I did not, I don't think, order that you were off the case, so you were still on it regardless. So.
Great. Well,
I understood what she said to me, but I
here.
did not order.
State your name. Alexis Brown.
All right.
At this time, people are unable to proceed.
Move to dismiss. I did a lot of heavy lifting.
What'd you say?
I did a lot of heavy lifting on this one.
Yeah, okay. People being unable to proceed, this case is dismissed. That is without prejudice. Thank you.
Thank you.
Thank you.
All right, it is a relatively quiet day out in Courtlandia, but there's a few places we can go. Let's change it up a little bit. We'll go back to Judge Boyd.
23 CR 10366 State versus Claudel Dwayne Corney. Can I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Good morning, for the defense.
Christopher Ramos for the defense.
And are you Mr. Carney?
Yes, ma'am, this is me.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Ms. Boyd.
Are you the same Claudel Dwayne?
Yes, ma'am.
All right. Are you the same Claudel Dwayne Carney who was placed on deferred adjudication in 2023 CR 10366 for the offense of aggravated robbery on February 13, 2024 for a period of 10 years? Is that you?
Yes, ma'am. That's correct.
All right, state.
Yes, Your Honor, violation of condition number 41. On or about the 8th day of September 2025 in Bear County, Texas, the defendant, Claudel Dwayne Carney, did then and there fail to register for, attend a moral recognition therapy program with an approved agency in violation of condition number 41.
All right, if we could go off the record for a moment, I don't have a violation of condition number 41. Is that in a supplemental?
No, Your Honor, it's the original ETR.
All right. To the violation, how do you plead, true or not true?
True, ma'am. State will waive the other two violations, Your Honor.
Any objections to the state's waivers?
No, Judge.
Did you understand by pleading true to violation of condition number 41, court could find it true, grant the motion, find you guilty, and sentence you up to life in prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, Your Honor.
Court will find violation of condition number 41 true. Is there a proposed agreement?
There's not, Your Honor. Both state and defense are going to make the recommendations to it, Your Honor.
All right, state, what are you requesting?
Before I make my argument, Your Honor, I'd ask the court to take judicial notice of the court's file.
All right. What specifically do you want the court? I know you say the court's file, but is there something specifically?
The facts of the underlying offense and his history on probation.
All right. You may proceed.
Thank you, Your Honor. We're here for the defendant's motion on this aggravated robbery charge that he is on probation for, and Your Honor is aware of the facts of this case, being that he initially stole that victim's phone, ran away with it. The victim was lucky enough to later find him at a gas station close by, and when the victim asked for his phone back, the defendant pulls a knife on him and says, "Come and take it. Come and get it." With a deadly weapon, he threatened someone's life, therefore being placed on probation, for 10 years. We're here on the second MTR this defendant has had within the last 4 months. For same violations as it was just 4 months ago in June, Your Honor, where the defendant had a new number one that we unfortunately had to waive. That victim was his sister. He assaulted her. She did not want to come in to support that day.
Well,
I would strongly object.
all right, that objection will be sustained. If it was waived,
Okay.
then it will be sustained.
We reluctantly had to waive number one today. We were ready to proceed on the contested MTR yesterday. Victim here, sister here, to testify about what he did to her. They decided not to show up today. Therefore, we had to proceed on the technical violation of condition number 41.
Well, I
Given-
mean, if you would like, my understanding that there would be no objections. If they would like to zoom in, I was going to say it was working.
Formally, Judge, I don't remember, for the benefit of the record and on behalf of my client, I would have to object on their appearance on Zoom. I would ask them to appear in person.
Okay. All right, you may continue.
Only because of the defendant not coming yesterday, we were unable to proceed with trying to prove the assault that he committed against his sister on September the 4th, 2025.
Okay.
As such, because of the underlying offense, because of his history, because he had the opportunity that Your Honor gave him back in June to go to Louisiana like he requested, but instead chooses to commit new crimes. He feels that he is not an appropriate candidate for probation. He should be revoked. He should be adjudicated guilty. There should be an affirmative finding of deadly weapon. State is seeking that Your Honor sentence to the 10 years TDC.
All right, defense, you may proceed.
Specifically to speak to him not registering or attending the moral recognition treatment course. My understanding is that he failed to, at least the date alleged, is a date in September of 2025. As he describes to me, he was released from jail in July of 2025. And he does admit to me that he did not register for the class. And part of that where he was struggling was a combination of him dealing with, as the court may be aware of, some of his mental health struggles that he's dealing with. He reports to me that he is schizoaffective, dealing with bipolar. I believe probation has some information about that. And he was also struggling with transportation. At this moment in time, in September, I think he was just struggling to function as an individual. He was just struggling to function. But I would ask the court to be mindful that while on probation, as far as I can tell, he's completed some of the outpatient requirements. He's completed anger management. There were a series of events where he tested for substances and he came back a series of times negative. He's been to DDRF, and when I ask him about his experiences there, he's able to recite their philosophy, the things that he learned. He's describing that he learned strategies on avoiding conflict, on what his triggers are. And other than this allegation of assault and a minor relapse with the substance, I think he's doing the best that he can. I think he was living in a household that was pretty volatile. And I think he's living with other individuals that struggle with them. They struggle in terms of how to deal with his mental health issues. And it's a bad recipe.
Mm-hmm.
I have a sense that he's doing his best. He describes to me he wants to fight the new number one as it exists on its own because it's a new case. So we are respectfully asking the court to continue him on probation with some sort of jail sanction, and to be mindful that he has given his mental health, he's doing his best to accommodate, that's the wrong word, to fulfill the agreement he's made for probation. So for that, Judge, we're asking for you to continue him.
All right, probation.
We have his probation officer here, so we're going to like to hear from him.
No, I mean, what is the recommendation?
Oh, Judge, so what's listed on the court summary is DDRF followed by 6 months sober living at approved location, and ISP supervision upon DDRF, bi-weekly UAs for 60 days post DDRF. He did complete DDRF 121 days. He completed an outpatient program. He completed an anger management program. He has not completed the moral recognition therapy, the referral for Center for Healthcare Services. His last UA in August of 2025 was positive for amphetamines. And his last office visit with his officer was in August of 2025.
All right.
I'm thinking that's because maybe that's after that his respiratory.
Okay. So here's the thing, Mr. Carney.
Yes, ma'am.
I don't think you're appropriate for probation. I granted your application over the objection of the state.
Yes, ma'am.
And I can only do so much. What the court is going to do is the court is going to find violation of condition number 41 as previously stated. The court is going to sentence you to 6 years in the prison, give you credit for any time served. The court will recommend the therapeutic community. There's an affirmative finding of deadly weapon. The court will give you credit for any time served for successful inpatient treatment. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am. I don't want to say that you're moving too fast, Ms. Boyd.
Judge. No.
Miss,
Well, that's fine. You can call me Miss Boyd.
my principal in Shelby Middle name was Mr. Boyd.
Okay.
Ma'am, I get it. I just came home November 1st and consistently back in your courtroom, and I am ashamed. Also, ma'am, the new class that you signed me up for, told me to go to, I didn't have no transportation. I didn't have no kind of ride. I'm getting kicked out of this house that my brother had owned, caught a heart attack in, and they had multiple individuals in there. I haven't even spoke my mind about what's going on in this house, from guns, drugs activity, and Center for Healthcare helped me, got my food stamps. Just one of the two same sisters are still in my food stamps. Those are triggers that I learned. So I removed myself from that household consistently. But I always went back because you know why? That's where I probate to. That was my original.
No, so here's the thing. I
Yes,
tell
ma'am.
everyone who's on probation in this court, if there's an issue, all you have to do is let probation know about it.
I did, Miss Boyd, and also I was trying to tell you, like recently, I just cleared a $25,000 lawsuit. Only thing I did for myself, ma'am, was buy a brand new car. It was $12,000. It's in New Orleans. My niece was driving it to me the day that I got locked up, ma'am. Consistently, if the system, I'm not gonna say the system failed me. I love Mr. Alcantara, my probation officer. I wish he could speak up on my behalf. Ma'am, no. And I just moved back to San Antonio because I just recently found out in 2023, I have a 12-year-old baby that I didn't know, that I did not know I was able
So here's my question. Why didn't you contact probation and say all of this was going on in your life?
I tried, Miss Boyd. I really
I know.
did. Because I was in jail. I didn't know not one, but two of my siblings passed away. One of them overdosed from drugs. And
So here's the thing, what I want you to internalize.
yes, ma'am.
This is what I want you to internalize. I took into consideration your mental health issues
Yes,
when
ma'am.
I granted your application for deferred. And I granted that application for deferred over the objections of the state. So what that means is you need to be on what's called your P's and Q's and make sure that you're doing everything that you're supposed to be doing. And
Yes.
you're not. So I just don't think you're appropriate for probation.
Yes,
So I'm
sir.
not going to continue you.
Yes, ma'am. All right. But Mr. Alcantara, I can have a peaceful word with Mr. Alcantara before I leave
For
the
what
courtroom.
purpose?
Because he could tell you some of the things that I was going through before I got locked up, ma'am. I was explaining the stuff that you said that I wasn't explaining to probation. I was explaining to Mr. Alcantara. I knew it was going to be. I didn't know how it was going to happen, but I knew it was going to happen. I was going to fall off. Ma'am, I just bought this car. I didn't have no transportation to make the last class, and I was going to complete the last class. I even much have the money right now to pay off my whole probation. I just didn't. It's the people that was around me, man. My family did not want to see me make it. I have all my probation fines and fees, the whole 7,000.
Oh, here's the thing. Your attorney can address with you whether or not you should be spending money to pay that because you're no longer on probation. That would be money that
So I to do 6 years, Ms. Boyd.
you'll get credit for any time that has
You
been
could tell
served.
me how much time I served that do I have?
To the clerk, can you look up how much time?
And what about the credit for time served the last time when I was?
You'll get credit for any time that you've been in custody on this case, even prior to being placed on probation. Did you review the trial court certification of defendants' rights to appeal? You have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, Ms. Boyd.
All right, thank you. You're welcome. All right, so we'll be back on Monday.
Okie dokie, let's oh, hold on a minute. I'm hitting wrong buttons. Here we go. Let's go back to Judge Simpson.
Stefan, so I am appearing for this hearing only. I guess at his last pretrial when this was set, Ms. Stefan knew she was going to be at his last pretrial when this was set, Ms. Stefan knew she was going to be out of town.
Yes.
And asked the PD to step in. So I'm here. However, Mr. Jorgensen is not.
Okay. And what I will do is I will issue a bench warrant for his failure to appear. And just so that clearly what is going into the court's mind is he also has a warrant on another 14A1 case. So bench warrant will issue, bond setting amount $25,000. I'll give a 10% privilege on that. That warrant will issue immediately.
I'm not sure if anything else is ready. We're down to 4.
Anything else ready or?
Shendy, which I'm sure I mispronounced.
But I know what you were talking about.
Okay.
Sorry.
Court does call the case of the people versus Matthew Sydney.
Shemshadini.
Shemshadini.
Shemshadini, our first conversation, we practiced it. I kind of about 50% of the time get it right. So sorry, Assistant Public Defender Natalie Pate with and on behalf of Mr. Shemshadini, who stands to my right. Please state your name for the record, sir.
Matthew Shemshadini.
All right. Okay.
And Your Honor, Ashley Phelps from People, if I didn't already say that. Your Honor, in this case, while the named victim is the defendant's sister, she did not appear this morning, but parents of both parties did. But at this time, I can't represent that I could go to trial. So I'm going to say at this time, I'm unable to proceed. There is a very good chance the case may end up being reauthorized, but at this time, I cannot represent that I can proceed.
Motion to dismiss, Your Honor.
This time, people being unable to proceed at this time. This case is dismissed. That's without prejudice.
Thank you, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Okay. We ready on anything else or?
Ready, Mr. Nalette.
And Mr. Hop, I think we're ready.
I just have to run back on Mr. Hop and get signatures and stuff, so I need a few minutes on that.
Okay. You're in custody, you mean?
Yeah.
All right.
So I'll go do that now.
Okay. Is your client in custody or no?
Yes, Your Honor.
Okay. So I'll wait or we can, I don't know how many people we've got back there.
That would
Somebody,
be quick.
which one?
Mr. Bernstein's client.
Okay, let's get him out then. And then you can go back. I just didn't want them jammed up back there. I didn't have a lot of folks.
Yes.
All right, well, they're sorting out where they're going to go next. Let's go to Clayton County, where they do hallway court. We've got them lined up against the wall. Let's see how that's going.
We have 3 charges here today. The first charge is warrant 2025 CW 57202, false statements or writings, in that you are alleged to have knowingly and willfully falsified, concealed, or covered up by any trick, scheme, or device a material fact. I am denying bond on that charge today. You're also charged with party to a crime in that you are alleged to have intentionally aided or abetted in the commission of concealing the death and whereabouts of the victim, Nakai Pratt. I have denied bond on that charge this morning. You are lastly charged with a misdemeanor of obstruction of an officer. I am going to assign a bond on that misdemeanor of $5,000, but no bond on the other 2 charges. Your preliminary hearing will be scheduled for November the 12th at 8:30 a.m. And give me just a moment here. And I am going to assign a court-appointed counsel to your case, and that will take care of everything today. Thank you. And deputies, I'll take Antonio Pierce next. Okay. And are you Antonio Pierce? Okay. All right. So, Mr. Pierce, you have 7 charges before me this morning. The first charge is murder with malice. That is warrant 2025 CW 57195. It is alleged that you knowingly and intentionally with malice killed your 6-month-old son, Nakai Pratt. That is, there's no bond on that charge. Only a superior court can set a bond on that type of charge this morning. Your next charge is aggravated battery. It is alleged that you maliciously caused bodily harm to the person of Nakai Pratt by causing bodily harm to his head. I've denied bond on that charge. That is warrant 57197. Warrant 57198, aggravated assault with the intent to murder. It is alleged that you did assault upon the person of Nakai Pratt with the intent to murder, causing substantial injury to his head. I've denied bond on that charge this morning. Warrant 57199, felony tampering with evidence. It is alleged that you knowingly and intentionally tampered with evidence by asking a witness to hide a book bag containing drugs and a handgun, and by taking the missing child's body and attempting to hide it along a fence line. I have denied bond on that charge this morning. Warrant 57200 is concealing the death of another. It is alleged that you knowingly and intentionally did conceal the death of Nakai Pratt. I've denied bond on that charge. The last charge here is a misdemeanor, that is false report of a crime. It is alleged that you willfully and knowingly filed or caused a false report to be provided to law enforcement. I will place a bond of $10,000 on that misdemeanor, but no bond on the other charges. Your preliminary hearing is going to be scheduled for November the 10th at 8:30 a.m. It's my understanding that your other charges are already scheduled for that date, and I am going to assign a court-appointed attorney to your case, and that will take care of everything for us this morning. Thank you. All right, and I think that takes care of both cases that we had media requests on. So if the folks from the media, thank you guys very much for joining us. You all can log off now. And so the next case I will take will be Kiana Hill.
I'm clear, Your Honor.
Okay, thank you.
Judge, can you please look at your message?
Hang on just a second.
214.
Yeah, that's fine. Thank you. Okay, and ma'am, are you Kiana Hill?
Yes, Your Honor.
Okay, your attorney, who is Miss Blake Stewart, is here, and I'm going to speak with her about your case for just a moment. So Miss Blake Stewart, there are 3 charges here. Do you want me to read the charges?
I have them, Your Honor.
Okay. Is there anything you want me to know on the issue of bond?
Yes, Miss Hill is 32 years old. She's a graduate from Banneker High School. She is enrolled in Atlanta Metro College. She is a sole provider for her grandmother at this time who has cancer, Your Honor. Miss Hill also has a rental car business in which one of her vehicles that she returned from one of her customers, there was a tag on the vehicle that came back stolen. That's where the theft by receiving stolen property came from. Your Honor, I am asking for a UJR bond on the driving on suspended license and the theft by receiving stolen property, asking for a $2,500 bond on the identity fraud. Ms. Hill does not have a felony criminal history, from my understanding.
If I understood correctly, you're saying she has a rental car business, so this is a vehicle that had been rented out to someone and then come back to her? You're saying?
That's correct.
Okay. All right. I understand. All right. So what I'm going to do, that suspended license bond it's a preset bond at $1,500. I'm just going to leave it as is. On the theft by receiving stolen property, I'm going to lower that down to $1,500. On the identity fraud, that's going to be $3,000. So it's going to be a total bond of $6,000 on her. I'm going to put special conditions. I don't know her if she has any connection to the alleged victims here, but Jamal Eason and Rodrika Turner. Does she live with either of those individuals?
No, Your Honor.
Okay. All right. We're just going to put a no contact provision on with the alleged victims then there. The preliminary hearing will be November the 12th at 8:30 a.m. And I will note here that she has private counsel. And I think that takes care of everything on this one. Anything further?
Nothing further, Your Honor. Thank you.
Okay. Thank you. And Ms. Hill, thank you. That'll take care of everything today. All right, and deputies, next up, I will take Roger Richards.
Good morning, Judge.
Okay, good morning. Let me find that paperwork here. All right, so just, sir, if you can confirm for me, you're Roger Richards, is that correct?
Yes, Your Honor.
Okay, thank you. Your attorney, Ms. Kurt, is here, and I'm going to speak with her about your case for just a moment. It's a criminal trespass charge. Ms. Kurt, anything you want me to know on bond on this one?
Yes, Judge. He's been a resident of the Metro Atlanta area since 2000. He's employed. He's missing work right now today. He's very eager to get back to work so he can support his family. He lives in the area. Both of his parents live in the area, his stepmother, 2 aunts, and 4 cousins. So he has deep ties to the community. I don't believe he's got any history, Judge. He actually retained me last week for this matter, and that he actually retained me last week for a traffic matter, and that is when he learned of the existence of this warrant, Judge. He had planned to surrender as soon as I had a break in my work schedule so I could appear for the bond, and he got picked up before that could happen, Judge. But he had retained me last week, Judge, so he totally intends to get this matter resolved, Judge.
Okay. And am I correct? So I'm just gonna set the bond at 1,000.
That's what I would have asked, Judge.
And so my understanding, he no longer lives at this Sandalwood Court address. So, okay. So a stay away provision won't cause him any complications.
No, he's
Okay.
absolutely, yeah. He lives 5192 South Park.
Okay. And a no contact provision with Brittany Roden.
Is no problem.
No problem there. Okay. Good deal. All right. So we'll do that. From the allegations here, I understand he may have had some possessions that were still in that apartment or that home. Does he still have possessions there he needs to get?
Mr. Richards, do you still have any possessions at the old apartment you need to get?
Don't have any. Oh, okay. So, okay. All right. I was just going to see if we needed to put a provision in there that would let him come back. But if he's got all his items out, then everything's good to go there. All right. So preliminary hearing will be scheduled for November the 11th. I understand he may post bond before then. Mm-hmm.
I anticipate him the bond being posted very shortly.
Okay. Okay. And I think that takes care of everything on his case. Anything further, Ms. Kurt?
Nothing further, Judge. May I be excused?
Yes. Thank you. Thank you very much.
You.
And good to see you, Mr. Richards. Thank you very much. Give me just a moment to get this paperwork squared away here. All right. And yeah, deputies will take Eric Vasquez. Okay. Okay. Are you Eric Vasquez, sir?
Yes, sir.
Okay. Thank you. Your attorney, Mr. Malone, is here, and I'm going to speak with him for just a moment about your case. Let me find that paperwork here. All right. Mr. Malone, do you want me to read? There's 5 charges here. Do you want me to read them?
If you wouldn't mind, Your Honor, just so
okay.
I can make sure I'm clear as to what they are.
Sure. All right. There are 4 misdemeanors. So there's loitering, simple assault, criminal trespass, and contributing to the delinquency of a minor. The last charge is felony terroristic threats. And is there anything you want me to know on bond?
Yes, Your Honor. Eric is a 17-year-old who lives with his mother in Clayton County. Her name is Chrissy Vasquez. He works full-time at Captain D's, which is a fast food chain in Clayton County. And I understand that this incident stemmed from something that happened in his neighborhood. He has a younger brother named Santiago Vasquez, who also lives with Christy. They were hanging out with some older people who Eric believed was a bad influence. And so I do believe that he'd be willing to comply with any reasonable conditions of bond, like a stay-away order from that trailer home. But he would like to live back in the neighborhood with his mother, Christy. Would ask the court to set reasonable bond on the felony terroristic threat. I don't know exactly, I haven't gotten an incident report yet about what the alleged threat was. But as your honor knows, there's often a tippy toe between misdemeanor and felony terroristic threat.
Okay. All right. Um, is he in school or just working full time?
No, he's working full-time, but he is in a course for GED, your honor.
Okay. All right. I'm going to adjust some numbers here. Give me just a moment. Okay. So on the loitering, we're going to set that bond at 1,000. On simple assault, I'm going to set that at 1,000. On terroristic threats, I'm going to set that at 3,000. Criminal trespass, I think that was related to a shattered window. I'm going to leave that there at 2,000. The last charge contributing to the delinquency of a minor, I'll set that at 1,000. So when I add that all up, that comes to 8,000 total bond. We'll put in here that he is not to return to 156 Black Forest Trail in Stockbridge. And I think the preliminary hearing will be scheduled for November the 12th at 8:30 a.m. And I think that takes care of everything. Anything further, Mr. Malone?
No, that's it, your honor. Thank you.
Okay, thank you. Good to see you. And Mr. Vasquez, thank you.
Thank you, your honor. May I be excused?
Yes, thank you. Good to see you. Uh-huh.
Thank you.
All right. And yeah, deputies, we can go ahead with the females now.
Sir.
I think I got everybody. Any other attorneys?
Only got three.
Okay.
I don't think so, your honor.
I think that was it.
Okay, friends, just an update for you. Again, it's been a very slow day out in Courtlandia. Not a whole lot going on. We'll probably ride with Clayton County here until the bottom of the hour unless something else comes up. But good news for the regulars out there, Dungeon Court is in session. So wouldn't surprise me if the last half hour is Dungeon Court. So stay tuned.
You'll need to stay away from and have no contact with the alleged victim, Aubrey Mitchell. I understand that you all live together. Is that correct? Okay, so that means for the time being, you'll need to stay away from the residence. We will put into the bond order that you can contact the sheriff's department within the first 10 days of your release, and they'll give you a date and time that you would be allowed to go in and get what personal items you need for the time being out and without violating your bond. You can also talk to your attorney about how to get that bond condition changed over time, just to maybe start allowing contact if Mr. Mitchell is on board with that down the road, okay? The preliminary hearing will be scheduled for November the 11th at 8:30 a.m., and I am going to see that a court-appointed attorney is assigned to this case, okay? And that'll take care of everything today. Thank you, ma'am. All right. Good morning, ma'am. Can you state your name for me?
Ashley.
All right, Ms. Collins, you are charged with theft of services. That's being charged as a misdemeanor. The bond is going to be $2,000. There will be a special condition that while out on bond, you're not to return to this salon or shop here at 7952 North Main Street in Jonesboro. The preliminary hearing will be November the 11th at 8:30 a.m. And I'm going to find that you do qualify for a court-appointed attorney, and we will get somebody appointed to represent you. And that'll take care of everything this morning. Thank you, ma'am.
Thank you.
Mhm. All right, and good morning, ma'am. Can you state your name for me? You'll have to say your name kind of loudly there.
Janice Darden.
Miss Darden, okay. All right, so Miss Darden, you have one charge, that is theft by shoplifting, that is being charged as a felony. The bond on that will be $2,500, and while out on bond, you are not to return to the Walmart at 7050 SR 85 in Riverdale. The preliminary hearing will be scheduled for November the 12th at 8:30 a.m. And I am going to see that a public defender is assigned to represent you on this. And that'll take care of everything this morning. Thank you, ma'am. All right, good morning, ma'am. Can you state your name for me?
Patricia Donald.
All right, Miss Donald, you have one charge, that is battery. The bond on that will be $3,500. While out on bond, you are to stay away from and have no contact with the alleged victim, Talicia Boyd. Do you and Miss Boyd live at the same residence? So sorry, it's on mute there. But you do not live at the same residence. Okay, so just have no contact with that person while you're out on bond. The preliminary hearing will be November the 11th at 8:30 a.m. And I am going to see that a court-appointed attorney is assigned to represent you on this, and that'll take care of everything this morning. Thank you, ma'am. Mhm. All right. Good morning, ma'am. Can you state your name for me?
Genesis Grist.
All right, Miss Grist, you have two charges here. The first is a felony. That's criminal damage in the second degree. We're going to set that bond at $2,500. The next charge is battery. We're going to set that bond at $3,500. So that gives you a total bond of $6,000. While out on bond, for the time being, you will need to stay away from and have no contact with Christopher Grist. Is that your husband? I'm sorry?
Yes.
Okay. So for the time being, you need to have no contact with him. You can talk to your attorney about how to get that bond condition changed over time to start to allow contact again if he is on board with that. So that means also that if you all are living at the same residence, that means for right now you can't go back to the residence. But I will put into the bond order that you can contact the sheriff's office within the first 10 days of your release, and they'll give you a date and time that you would be allowed to go in and get personal items that you need. Okay? Just make sure to schedule that in the first 10 days that you're out. The preliminary hearing will be scheduled for November the 12th at 8:30 a.m. And I am going to see that a public defender is appointed to represent you, and that will take care of everything on your case today. Thank you, ma'am. All right, good morning, ma'am. Can you state your name for me? I'm sorry. Miss Hurd, okay. All right, so Miss Hurd, you have two charges here. The first charge is cruelty to children in the second degree. That is a felony. That bond is going to be $4,000. The next charge is abandonment of dependent children. That bond will be $3,000. So your total bond is going to be $7,000. We're going to set your preliminary hearing for November the 12th at 8:30 a.m. And based on your application for an attorney, I find that you do qualify, and I will see that a public defender is appointed to represent you, and that'll take care of everything today. Thank you, ma'am.
All
All right, good morning, ma'am. Can you state your name for me?
My name is Portia Lockwood.
All right, Miss Lockwood, you have two charges here. There's criminal trespass. We're going to set that bond at 1,500, and then there's battery. We're going to set that bond at 3,000. So your total bond is going to be 4,500. While out on bond for the time being, you are to stay away from and have no contact with Michael Young. Now, it's my understanding that Mr. Young is also here on charges related to this incident today
Yes.
as well. So we got to figure out who gets you guys live at the same residence?
No, not all the time, no, sir.
Oh, you aren't living at the same residence.
No, not all the time. He stays in Fayetteville, Georgia.
Okay, when you say he doesn't live there
I
all the
say-
time, what do you mean?
Yeah, because both of our names are on the lease.
Mm-hmm.
Yeah, my children, well, I have two that's in school. One in elementary, goes to Point South Elementary School, and my
So
Monday to high school.
your children are at this residence on Point South Parkway all the time then?
Yes, sir.
Okay. All right. All right. So what we're going to do is we're going to say, I'm going to tell him the same thing, that he's not to have any contact with you. I'm going to bar him from coming back to the residence. Okay.
Yes,
So
sir.
you'll be able to go back to the residence. And so we're not going to interrupt children's school and that type of thing.
I
So,
appreciate that. Thank you so much. yeah.
okay. Okay. Just don't have any contact with him for right
Okay.
now.
Yes.
And then talk to your attorney about how, if you want to get some contact down the road, how that can be done. Okay.
Yes, I would like to do that.
Okay. So talk to your attorney about how that process works. The preliminary hearing will be scheduled for November the 11th at 8:30 a.m. And I am going to assign a public defender to represent you on this case.
Thank you.
And that'll take care of everything for us this morning. Thank you,
Okay.
ma'am.
Thank you for your time.
Mm-hmm. All right. And good morning, ma'am. Can you state your name for me? I'm sorry. The network kind of broke up. Can you say it again for me?
Chinese Marks.
Miss Marks. Okay. All right. So, Miss Marks, you have one charge, that is theft by shoplifting, that is being charged as a felony. The bond is going to be $2,500. While out on bond, you're not to return to the Walmart at 7050 SR 85 in Riverdale. Your preliminary hearing will be November the 12th at 8:30 a.m. And I will see that a public defender is appointed to represent you on this charge. And that'll take care of everything today. Thank you, ma'am.
If I may interrupt the proceedings for just a moment, this is an announcement for everybody, but especially for Barbara. Barbara, pay attention to what I just dropped into the chat.
India Mercer.
Miss Mercer? Okay. Okay, so Miss Mercer, you have got, hang on just a second. I think there's a charge missing here. 30. Driving under the influence. Okay. Yate, just a heads up, there's a charge missing off the bond order. It's a DUI charge. It's warrant 2025 WA 08931.
Your Honor, it's on page 1 of 2.
I'm sorry?
To print that out for you. It's on page 1 of 2.
Yeah, it's missing from the bond order.
Oh, understood.
Gotcha. So it just needs to be put into CPU 8.
Okay, thank you.
Okay, thanks. Give me just a moment, Miss Mercer. Okay, so Miss Mercer, you've got 5 charges here. The first is a felony violation of the Georgia Controlled Substances Act. That bond, I'm going to set it at $2,000. The remaining charges are misdemeanors. So there's a speeding charge. We're going to set that bond at $500. There's driving under the influence. We're going to set that bond at $2,500. There's driving on a suspended license. That bond is going to be 2,000. And then there's no driver's license charge. I'm going to knock that down to 500 there. Okay. And so when I add all of these up, let me do some math here. 7,500 is going to be your total bond today. The preliminary hearing will be November the 12th at 8:30 a.m. And I am going to see that a public defender is appointed to represent you on these charges. And that'll take care of everything today. Thank you, ma'am. All right. Good morning, ma'am. Can you state your name for me?
Courtney Nevels.
All right, Miss Nevels, you have got two charges. So there's criminal trespass. I'm going to set that bond at 500, and there's simple battery family violence. I'm going to set that bond at 1,000. So your total bond is going to be 1,500. I would generally put a condition in here that says you were to have no contact with the alleged victim. I know that is this your fiance?
Yes, I'm pregnant right now.
And you're pregnant right now? Okay. I know that he has contacted us to our office to try to find out how to get you out. And so what I'm going to put in here, and I know your status there a little bit. So what I'm going to just put into your bond order is that you're to have no violent contact with him. I know you're charged with simple battery, and it was the allegations here are a push, not a striking, but a push. So that's why I gave you a low bond, and we're just going to put no violent contact with Mr. Haynes. So just make sure that nothing else happens when you get home. Okay. All right. And the preliminary hearing is going to be November the 11th at 8:30 a.m. That'll be canceled when you post bond. And then you'll get a notice from state court in the mail telling you when to come back for your arraignment hearing. I'm also going to assign a public defender to represent you, and that'll take care of everything for us today. Okay. All right. Thank you, ma'am.
Thank
you. Mm-hmm.
We have one more medical.
Okay.
Like for you to do if that's okay.
Yeah, that's fine. Just tell me who it is.
Last name is Simmons.
Simmons. Okay. All right. All right. Kenlisha Simmons. Is that right? Okay. So Ms. Simmons, you have got 4 charges. There's battery. That bond is 3,000. You're charged with 2 counts of criminal trespass. They'll each have a bond of 1,500. The last charge is felony criminal damage in the 2nd degree. That bond is going to be 2,500. So when I add these up, I get a total of 8,500. While out on bond, you'll need to stay away from and have no contact with the alleged victim, Joseph Glover. It's my understanding that you all live at the same residence. Is that correct?
Yes.
Okay, so for the time being, you'll need to stay away from the residence, but you can contact the sheriff's department within the first 10 days of your release, and they'll give you a date and time that you would be allowed to go in and get personal items out. You can also talk to your attorney about how to get that bond condition changed over time. And I am going to assign a public defender to represent you. That'll take care of everything today. Thank you, ma'am.
Okay.
Vernica Reeves.
Miss Reeves. Okay. All right. So, Miss Reeves, you have got 2 charges. I know this stems from a 2024 incident here. They're both misdemeanors. So you're charged with disorderly conduct. That bond is 1,500, and you're charged with affray. That bond is 1,000. Okay. And while out on bond, you'll have a special condition here that you are to stay away from and have no contact with the other individual involved in this, Kaya Caldwell. Your preliminary hearing will be scheduled for November the 11th at 8:30 a.m. And Based on your income level, you do not qualify as indigent under Georgia law, so you don't qualify for the public defender program. You'll need to hire your own attorney if you would like an attorney to represent you on these charges, okay? All right. And that'll take care of everything for us this morning. Thank you, ma'am. Mhm.
Okay, friends, about the bottom of the hour, so it's time for our guilty pleasure. There's a lot of potentially new viewers out there today, so allow me to explain something. We're about to go to something called Dungeon Court. Now, it is the guilty pleasure of this channel for sure, because it's so bad, that's what makes it good. It's a dark, dank basement with Cold War Soviet-era lighting, a backdrop that looks like, frankly, dungeon walls. Audio's horrible. The carpet is ripped straight out of The Shining. We actually call it Shining Crimson. You can hear the screams and moans of young children in the background. The souls of the dead are clearly present. It's an interesting place. Ladies and gentlemen, it's Friday. Let's go to Dungeon Court.
Would be good to see something from PATH to see how things are going. So maybe if Adria could arrange to get us a written report next time.
I'll have to call the office. I'll need the court's email address so they can get that.
Well, they have sent reports previously, so they should have that.
Yeah, well, it might be because she was just there this morning over the phone. It's probably
And
going to be prepared.
I had to change therapists because Cecil Diamond quit and I'm with Maggie Howard.
All right, well, let's try to get a report, come back. 17th,
Yes, sir.
November 17th.
November 17th at 10.
You got it. Keep up the good work you're doing. Excellent. Yeah, well, that's what we want here.
Have her email that to the judges.
They've been sending emails, they're already getting them, they just didn't have one for today yet. So I'm assuming they'll type that up this afternoon or Monday. Just keep doing what you're doing, we'll see you the 17th.
So I have to get in the phone. I haven't been able to text you.
Do you have the same number? Or different
Yeah.
number? Okay.
So if you could shoot me a text.
I'll shoot one, then we have it. All right.
State of Ohio versus Megan Lynn, case number CRD 25661, A and B, set for arraignment, Your Honor.
Thank you.
And are you Megan Lynn?
Yes, sir.
Ms. Lynn, were you here while explaining the rights that defendants have?
Yes, sir.
Do you understand your rights?
I do.
I'm going to go over the two charges with you. There's two, 661A and B. The A case is a domestic violence charge. It alleges that at Fayette Township on October 16th, Middleton calls and tried to cause physical harm to Robert Boca, and that Robert's either a member of your family or lives in your household. That's a first-degree misdemeanor domestic violence, maximum penalty 6 months in jail, $1,000 fine. Is Robert Boca here today? Okay, apparently not. The B case is criminal damaging. It alleges at the same time in place, you knowingly caused a risk of harm to property of Robert Boca without his consent. That's a first-degree misdemeanor criminal damaging charge. Maximum penalty 6 months in jail, $1,000 fine. Do you understand the two charges, ma'am?
I do.
How do you wish to plead?
Not guilty.
You want a lawyer appointed for?
Court-appointed attorney, please.
Are you working?
I am.
What do you do?
Shakery in South Point.
Are you paid by the hour or are you get paid?
Hourly wage and tips. $8 an hour, and then I keep my tips.
I have to determine your gross annual income. Do you know what that would be?
I have paycheck stub on my phone.
Do you have children?
I do.
How many?
2.
Okay, you're going to be eligible, so. I'll appoint Mr. Steyer to represent you. is entered. She has a bond up, oh yes, she has a bond up, so her bond's continued.
Now, I assume if she's posted bond that she's been fingerprinted.
Yes, sir.
Protection order requested.
We'd like to know what the circumstances are, if they were living together.
We were living together. I'm sorry.
And whether she can go home or not.
He has somewhere to go.
My house, he left.
Okay, he's left the home.
So we'll ask for a protection order just to.
Is it any problem for you to stay away from him?
No.
Okay, so I'm gonna order that just so that
Okay.
nothing further is alleged to happen.
That's
So you
perfectly
stay
fine.
away from him. If he comes around you, he's not here for me to order him to do anything. If he comes around, you retreat, go in your home, call the police.
Gotcha.
Don't try to engage with him.
No, I made the mistake the first time, sorry.
No, please, don't say that.
I'm setting pre-trials in November. About the only date that's booked out is the 7th. Any other date in November is good.
Let me take a look at my calendar, Your Honor. Got a bunch of trials in November. I've got the 17th. Is Monday or Friday matter for you?
Nope.
Okay. 17th, 21st, 24th, and 28th. Well, 28th won't be a day, but 17th, 21st, and 24th are all available.
Let's do the 17th. November 17th will be the next hearing.
10 o'clock.
It'll be a pre-trial at 10 a.m.
No, you hang on to it. I'll get it called court. I'll make a copy for myself.
Federal Law versus Vicky Wilson.
Got them about
Case number
30 more
CRA
minutes.
25-537, set for arraignment. Vicky Wilson.
Mr. Stratton actually represents Mr. Wilson. Full set for a preliminary hearing on September the 19th. It's alleged Mr. Wilson did not appear then. So there was a warrant issued at that time.
Take your hat off, please, sir.
So what I think probably needs to happen, I have a report from Morris County Recovery. It's letting you talk with Mr. Wilson, Mr. Stratton, and we'll recall him after that happens. So he's been out of pocket since September the 19th.
Okay. Hey, have a seat out in the hallway right now.
That's the bail play when we're ready.
Yes.
State of Ohio versus Bruce Curry. Case number CRP 25-124.
Mr. Stratton's case, pre-trial today.
Things going well?
Yeah.
He's at RRS.
It's a little spotty. It's just good work and stuff.
All sort of work-related stuff.
Yeah.
Yeah, okay. I believe he's going to, well, he's already improved after discussion with them. I think it's a lot of work-related issues there, Your Honor, that he's currently working through, so. But he's, sounds like he's back on track.
It sounds like we still got stuff to work on.
Yes. Yes, sir.
Mid to late November, what's your schedule?
Any days except the 3rd, 10th, and 24th, so.
21st?
Yep, 21st.
November 21st will be the next hearing for Mr. Curry.
Thank you.
10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Adam Searles. Case case number CRB 25-646A and B. And then we'll have versus Courtroom Service, case number CRB 25-645.
Here's Sean.
The latter case is Mr. Steyer's case.
Mr. Steyer represents Courtney Searles and Mr. Brown represents Adams. There were some issues about personal property. Have those been resolved?
I don't know if they've been fully resolved. Apparently, he still has your social security card and has refused to return it, is what I'm being told. So I'm going to ask that if he has the social security card, that he return it. Any documents, any identification documents of hers that he returned.
Judge, there's a pending divorce. I think that's probably better for that. My understanding is he complied with, I haven't had an opportunity to talk to him about that, but my understanding is the court ordered him to give her her clothes and her medications, and he's done all that.
Why would he want to keep the social security card?
I'm not suggesting that he even has it, Your Honor, or has looked for it. I had an opportunity to go through that with him today. But there is a pending divorce. I believe she has other counsel.
There are other matters of property that I've told her we can't deal with, but I don't think it's unreasonable to ask for this court to tell him, give her her social security card. And if he doesn't have it, doesn't have it. But
I agree. If you have it, turn it over. If you don't have it, inform counsel that you don't have it, so it can be.
Indicate he doesn't have
You
it.
can go on the website and get a license card. Social Security has a website. So you can get a replacement pretty easily. I'm assuming she knows what the number is. But he should have no reason to have it either. If he has it, he needs to turn it over. Okay, so what else can we do?
well, beyond that, you're beyond the issues of property, which I think generally are probably something that are going to be a matter for the divorce court. We've discussed the possibility. I don't know if the state's actually said this, but this is a cross-filing situation, and one of the possibilities we had discussed was a 90-day continuance. Ms. Searles is agreeable to that. It looks like I'm seeing filling the paperwork out, so it looks like we're all in agreement that we can do a 90-day continuance.
Okay. So I think that takes us into January. #23rd of January.
Strangely, I have a jury trial that day. I was going to say that might take us far enough out that we don't have that problem. But the surrounding days, well, no, the 26th I have a jury trial as well, but the 30th I'm available.
Well, that's what we're going to discuss. What's the state's position on costs?
We would want one court cost.
Ms. Searles is not currently employed. Mr. Searles, I believe, is. So if he's willing to take that on, that may be a possibility.
If the court assesses court costs for him, he's not going to pay her court costs.
Well, it's one set somewhere.
The state asked for it.
I believe she has been employed for like the last couple of months. He's indicated that he's still willing to pay.
So are we going to fight over $125?
Probably in the divorce, Your Honor.
Yeah, okay. All right, so I'll put it down for the 30th. I think is that what we do, the 30th?
That's correct, Your Honor.
And it'll be dismissed then without appearance. That's worth $125. Dismissed without appearance if there's no further problems and the costs are paid on Mr. Searles.
Thank you, Your Honor.
When is it? When are we coming back on?
January 30th.
January 30th. But they don't have to appear if there's, they don't have to appear if there's problems or the costs are paid.
Take care.
Good luck.
There's a microphone right there.
Yeah. It's 2026.
I bet 25.
Okay, we gotta get used to it.
That's what I was gonna say. That'll be the 3-year, exactly. Because mine's January 30th, 2029. I'm really so mad at you. Like, really, actually, just
Believe me, I'm anticipating that.
That's not a picture. That was from like 3 years ago.
State of Ohio versus Dylan Adair, case number CRB 25679.
Mr. Stratton, case.
Yes. Of course, he's not here today. I spoke with Mickey. Yeah, I forgot her last name there. This morning, she was headed over there this morning, and she was
trying to find long-term placements, I understand.
Yeah, she actually was talking about RRS as possible placement for him. So she's going. So we're just going to work on doing that. If we can set it back maybe a week, we'll probably have some info on that. So
We probably should, I think, set it for Monday, because it's my understanding they can only keep him for a limited period of time, and then he's got to either go back to the jail or get released, so.
yeah, it seems like they were going to have a planned meeting this morning over exactly what they're going to do. But she said RRS is where she, and I know that, Jeremy, you have beds available, right? Yeah, so.
Well, let's put it on the docket. I don't know if you're available, but if
I'll
not,
be here.
we can do it by teleconference, telephone, but probably, if it's like the previous case that they were involved with, all we need to do is an entry confirming that they were permitted to go to that facility for treatment.
I'll be here Monday.
Okay.
Yeah.
So let's put it on the docket for Monday, the
Okay.
20th. It'll be a pretrial.
State of Ohio versus Evan Davis, case number CRB 25202.
Mr. Stratton's case.
Which one is this?
That is a pretrial. He's at Lawrence County Recovery. Good report, good screens.
You already got an additional report for you here.
Okay.
That talks a little bit more about some other stuff. It has the couples, what is it called?
Couples therapy counseling.
Yeah, couples therapy counseling.
Okay.
Yeah, sorry, Mr. Keel, I should show it to you first. But, we were talking about dismissing this once he completed his counseling and Where's the CPS case at?
Lawrence County.
I mean, what's the status of that?
Tuesday, we should be wrapping up, I hope.
Tuesday, this
Yeah.
coming Tuesday?
Yeah.
So it sounds like the CPS case is gonna wrap up probably this Tuesday, so. And those were the two things that he needed to do to get his dismissed.
He's still inpatient, you know?
Yep.
Okay. What's the state's position?
Well, we're pleased that they're making progress. We want to go through the completion of everything. So we'd like to come back again, and I don't know, maybe a month from now, is he still going to be in treatment at that time?
Well, it's kind of, he's doing really well, so it kind of depends on how Tuesday goes and then further.
We can come back sooner than I'll check. He's working now, I take it?
Yes.
Okay. Is, Ms. Maynard here today? Has the state any contact with her?
Yes, she says everything's going well. She's ready for the charges to be dismissed. And she indicated that he would bring verification of the counseling today, which I guess he has. So we want to hear what the Children's Services case, what the outcome of that is.
Okay, so the Children's Services is also involved.
Yeah, and then it sounds to me like once that's done, then that will be the determining factor in the completion of his residential treatment.
Yep.
So I guess we can come back fairly soon.
How about the 3rd of November?
I'm not available the 3rd.
7th or 10th?
The 7th.
November 7th will be the next hearing.
We're good.
Yeah.
Thank you, Your Honor.
You are.
State of Ohio, Mrs. Kelly Green, case number CRD 49489.
Mr. Stratton's case.
So, yeah, that's all right, we'll let you out. Your Honor, we just need to reset this for another pretrial, maybe on the 6th that we had just set.
I didn't hear the
We just need to reset it for another pretrial, this case.
And what date did you suggest?
The 6th?
7th? November 7th.
November 7th, I'm sorry.
That's a Friday. All right, defendant's request, case November 7th for pretrial, 10 o'clock.
All right, there you go. Okay.
Is there any discovery issues we need to?
Well,
Do you have?
I'll have to get discovery, yes, that's the reason why I want to reset. But, well, we need to get whatever they have, so, but you go take care of your personal matters, okay? All right.
State of Ohio recalls Mickey Wilson, case number CRA 25537.
All right, Mr. Stratton represents Mr. Wilson. He had been out of pocket for a little over, well, not quite a month. Missed the hearing September 19th by my record, so he's here today. And it looks like he's at Lawrence County Recovery.
Yes, Your Honor, he was, I think, initially worded to go RRS. He had some major family issues that we would not like to, if you want us to approach, we'll discuss that, but, and he's just getting things back together right now, and so I just asked that his bond be continued or his bond be reinstated, the warrant withdrawn, and him put back on the path that he was on.
And he's, is he inpatient now, or what's his, how is he receiving services? Outpatient.
He's outpatient right now.
Okay. What's the state's position on it? It's a felony possession.
Well, I suppose that there's been adequate consideration of whether it ought to be residential or outpatient at this point?
We actually recommended inpatient.
Well, that maybe needs some discussion.
Yeah, because he was ordered initially to go to RRS, and I'm told he left treatment.
Your Honor, may we approach?
Yeah.
Reach outpatient to see how it goes.
Yeah.
1505.
Just let the court know where you're living at, your current address.
1505 Lawrence Street Apartments.
So, Your Honor, I asked that we try outpatient, and he understands if he doesn't do well in outpatient, that inpatient would be where he would go.
Okay, we'll try it for a couple weeks. Set the next hearing if you're available the 31st.
Yes. Yep.
Okay, October 31st, 2 weeks from today. Do you want to stay outpatient? You need to do it.
All right.
That's a preliminary hearing. 10 o'clock.
All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Pretty good.
State of Ohio versus Trevor Dement. Case number CRA 25389, CRA 25311A and B, CRA 24344, CRA 23380.
All right, Mr. Dement's teleconference, his attorney, Mr. Stires, here in person. Yes. Getting a report from Shawnee.
Thank you.
Okay, it's a good report.
10:31.
Your Honor, it's a very positive report. We have quite a few different things pending here at this point. I'm not sure what the state's pleasure or the court's pleasure at this point is.
What's the state's position?
No, I'm glad to see the word impressed in there. That means he's really doing good. We've had him for one thing or another for quite some time. And so the charges that we have, the most current charges involve a possession charge and the paraphernalia charge. And he'd already pled guilty to some other charges. Well, we want him to continue on and be successful, maybe it's gonna stick this time.
Let's hope.
So we're okay with continuing again and,
What sort of a time frame would the court be looking at, Your Honor?
Month.
Okay, so, here we go. November 17 is a month when I'm available.
November 17th, Mr. Mint will be your next hearing. Good job. Keep working at it. Don't quit.
Here pretty soon, I'm going to be looking to get out of line and get a place in town. Is that something you are just going to bring that up?
Well, Your Honor, my guess on that, he doesn't have a monitor on at this point, so my understanding, my guess would be that the court's position would be that whatever the treatment center says he's able to do and ready to do is when you'd like him to do that.
Correct. I agree. So whenever they say you're ready for outpatient, then I'll be on board with that.
I'll get with his clinical team and
Okay, talk to your treatment team. Your next hearing is in a month, November 17th.
All right.
Thank you.
Thank you, Your Honor.
All right, friends, it is that time. Reminder to channel members out there, if you do not already have your copy, reach out to me via the members email, and I will send you a copy of the Dungeon Court brochure. You will LOL and LMAO. You'll do both of those things when you see the copy, I guarantee you. So be sure to get that. Also, be aware of what's posting later today on the channel. If you're a channel member, you already have access to these videos, but they'll post as the day goes on for everybody else. We have a Judge Oakley video coming up today where we have a state trooper who admits on stand that he lied to the suspect during a stop. We have a video from Judge Boyd going up where a dispute over a $63 charge led the defendant to make a bunch of threats, including, and I quote, "Google my capital murder charge." And then from Judge Middleton's court, we have somebody who pleaded karma to the charge against her. Her plead was karma. So be sure to check those out. We'll be back tomorrow, 8 p.m. Eastern, 5 p.m. Pacific for game night. That will be our last game night for a few weeks, so you'll want to be sure to join us for that. We're going to try to get past that level that we got stuck on in Unravel, or we'll spend 2 hours trying, either way. And then we'll be back here, obviously, on Monday morning, 10 a.m. Eastern, 7 a.m. Pacific for this show, 45 minutes early for channel members. So go have yourselves a good Friday and a great weekend. I look forward to seeing you all either Friday night for game night or Monday. Appreciate every one of you. Take care. God bless.